I've been tortured in that jail, attacked, and no one does anything about it. You probably have never taken a walk through the tunnel.
He was in absolute shock when he heard the gun went off, and he had no idea that the gun was loaded.
Did you see us out there doing anything illegal? Did you see us out there selling drugs? Did you see us out there people? No. And that's the difference between you and me.
In June 2016, Mark Dublino, a 54-year-old man from Cheektowaga, New York, launched a terrifying attack that left 3 people seriously injured and an entire community shaken. Violating an order of protection, Dublino broke into his ex-girlfriend's home in Williamsville and assaulted her and her friend with a weapon. Not stopping there, he drove to her parents' home and attacked her elderly father. These brutal assaults left all 3 victims hospitalized and marked the beginning of a long legal battle. In January 2018, a jury found Dublino guilty on 9 charges, including 2 counts of attempted murder, 4 counts of burglary, 2 counts of assault, and 1 count of aggravated criminal contempt. On March 23, 2018, during the sentencing, Dublino showed little remorse, claiming the victims were exaggerating their injuries.
That lied could never have gone through what I've gone through, and I'll continue to go through it. But I am sorry about their injuries, but they are overblown. They were out and about, and neighbors have seen them out and about, and they've been doing their activity, and they're gonna have 100% recovery.
Meanwhile, his victims, who once considered him family, expressed relief that justice had finally been served.
Thankful that this is all over with and justice has been served and we can move on with our lives, put this all behind us.
We've had so many thoughts about his action and how he could even do the things he did.
The courtroom also learned that Dublino had allegedly assaulted his attorney while in custody, facing additional charges for that incident.
I've been tortured in that jail, attacked, and no one does anything about it. You don't know anything about it. You probably have never taken a walk through the tunnel. Why, maybe I know what Jesus Christ walked over 2,000 years now through.
Dublino was sentenced to 107 years in prison by State Supreme Court Justice Deborah Hendiges. Although he plans to appeal, and legal experts suggest the maximum he can serve is 75 years under New York law, his conviction brought closure to those he harmed. He remains in state custody as of the latest updates. Just 4 days after being released from federal prison on June 13, 2019, Dalquavis Ward walked into Teaser's Bar and Grill in Racine, Wisconsin, with the intent to commit armed robbery. On the night of June 17th, while allegedly attempting the robbery, Ward was confronted by off-duty police officer John Hetland. Hetland, a 24-year veteran of the Racine Police Department, tried to intervene and jumped over the bar to stop the suspect. In response, Ward pulled a weapon and fatally shot Hetland at close range before fleeing the scene. The shooting triggered a multi-agency investigation, and Ward was later identified through DNA evidence recovered from the crime scene, including from Hetland's clothing and the bar's rear doorknob. Ward was arrested in Milwaukee on June 27, 2019. He was charged with first-degree intentional homicide, armed robbery, and being a felon in possession of a firearm. The COVID-19 pandemic delayed his trial, leading to jury selection being held under strict safety protocols at Memorial Hall, where jurors could be spaced out.
Since the juror questionnaires went out, there have been some significant changes to the world. We are in the middle of a pandemic, and the country has experienced significant civil unrest. Is there anybody that feels they have a significant health concern related to the pandemic that they feel is necessary to share with the court and the parties? Does anybody on this panel feel that they have such strong feelings on these issues that they may directly impact their ability to be fair and unbiased in this criminal case?
In September 2020, a jury found Ward guilty on all counts. During the trial, prosecutors presented surveillance footage and testimony that solidified Ward's role in the killing. He was sentenced to life in prison without the possibility of parole, bringing some measure of justice to the family of Officer Hetland and the Racine community. On January 2, 2022, Nisha Harris Brazel was working at a Milwaukee Burger King when a tragic series of events unfolded. According to surveillance footage and police reports, a man named Antoine Edwards pulled up to the drive-through window and attempted to rob the restaurant while armed. Despite Edwards' claim that the robbery was staged with Harris Brazel's involvement, footage shows the girl refusing to hand over cash and calling for help.
As he sticks his body through, he's armed with a dark-colored handgun, which he has in his right hand.
In response to the chaos, her co-worker, Derek Ellis, a felon in possession of a firearm, pulled out a weapon and fired. Tragically, one of the bullets struck Harris Brazel, killing her.
You see a muzzle flash, and you can see what are believed to be spent casings fall to the ground. But he walks over to our victim and notices that I believe she.
Ellis fled the scene and turned himself in more than a week later. Both men were criminally charged in connection with the girl's death.
Shooting a gun, allegedly, at another person while another person is between you with one hand is plausibly unreasonable.
In court, Ellis was given a $30,000 cash bond and later sentenced to 1 year in the House of Correction and 4 years of probation for illegally possessing and discharging a firearm. Edwards, accused of orchestrating the robbery, was bound over for trial and ultimately pleaded guilty to felony murder. In early 2023, he was sentenced to 23 years in prison, the maximum penalty. Harris Brazel's family continues to assert she had no role in the robbery plan, maintaining that she was an innocent victim caught in a deadly confrontation. In August 2020, a night out turned deadly when 35-year-old Johnny Burnett's girlfriend, involved in an argument with Luis Zamora Jr. during a car ride, called Burnett to come handle this. Zamora, 27, had pulled over at a gas station near 17th and Rogers in Milwaukee. Within minutes, Burnett arrived in a truck, pulled up beside Zamora's vehicle, and opened fire from the window, fatally shooting him. Zamora had been out with his girlfriend and Burnett's girlfriend, who was caught in the middle of the dispute. The act was sudden, violent, and prosecutors described it as a senseless reaction to a personal conflict. Burnett was later arrested and charged. A jury found him guilty of all charges, including first-degree reckless homicide and possession of a firearm as a felon.
So the notion that you're just going to put your arm out a window and fire, that's by definition the epitome of a senseless act.
During sentencing, Burnett maintained his innocence, claiming his attorney was at fault. However, the judge emphasized the gravity of his actions and sentenced him to 40 years in prison with an additional 15 years of extended supervision, totaling 55 years. On February 6, 2019, Milwaukee police officer Matthew Rittner was shot and killed while executing a no-knock search warrant at the home of 26-year-old Jordan Fricka. As members of the Tactical Enforcement Unit breached Frick's door and announced themselves, Fricka fired rounds from his weapon through the doorway, striking Officer Rittner.
It allows the ordinary citizen to see the realities of police work and see how dangerous it can be.
Frick later claimed he did not hear the police identify themselves and believed someone was breaking into his home.
Did you have any intent in your mind to kill somebody as you were firing that gun?
No.
What did you intend to do?
To just defend myself.
You heard from the sergeants and from the officers themselves that have done, up to 5,000 search warrants, that nobody reacts this way.
However, testimony during the trial contradicted that, including statements from officers and Fricka's own girlfriend, who said she clearly heard the police announcement. After 4.5 days of emotional testimony, a jury convicted Fricka on all charges, including first-degree intentional homicide. The verdict came swiftly, with jurors deliberating for just 1 hour.
We, the jury, find the defendant, Jordan Fricka, guilty of first-degree intentional homicide.
This has been really, really hard and very traumatic for not just the family, for the entire police department, and I'd argue for the entire community.
To see the relief in their faces was amazing. I actually felt it, and it's going in there and just seeing that was amazing.
Milwaukee District Attorney John Chisholm emphasized that Frick knew he was firing at police and acted with intent to kill. Police Chief Alfonso Morales and Officer Rittner's family expressed relief at the outcome, describing the conviction as a step toward healing. Frica was sentenced to life in prison without the possibility of parole. On the morning of May 15th, 2025, tragedy struck a home near 53rd and Custer in Milwaukee. Selena Renee Dotson, a 28-year-old mother, was bathing her son Asher and his brother. According to the criminal complaint, she left the boys unattended in the bathtub while she cleaned the kitchen. Moments later, her older son came into the kitchen. After drying him off, Dotson realized that Asher was still in the tub, unresponsive and floating. A neighbor upstairs heard her screams, rushed to the scene, and performed CPR until paramedics arrived. Sadly, Asher could not be revived and was pronounced dead at the hospital at 9:45 a.m. The Milwaukee County Medical Examiner ruled the cause of death as an accidental drowning.
State of Wisconsin versus Selena Dotson.
Dotson was arrested at the scene and charged with child neglect resulting in death. During her initial court appearance on May 20th, she wept throughout the hearing.
This case is obviously sad. It's scary. And unfortunately, it's senseless. It's sad because, of course, it resulted in a death. It's scary because we know other people probably makes this mistake as well. And senseless because it could have been prevented. On the one hand, it's clear this was an accident that you will pay for the rest of your life, no matter what happens to you. But it also involved a death. And you want to make sure you recognize the seriousness of that outcome.
The commissioner acknowledged the case as deeply tragic, calling it sad, scary, and senseless. He granted her release without bail, but imposed strict conditions, namely, no unsupervised contact with boys and girls, including her own, while awaiting trial. In June 2019, a tragic incident unfolded inside a Kenosha home on 60th Street, where Dakari Weldon was fatally shot. According to investigators, brothers Javon and Jovan Cannon, both 24, were rearranging a bedroom with other adults when a loaded weapon belonging to Jovan was left within reach. Dakari reportedly began playing with the weapon. Despite Javon's attempt to stop him, the weapon striking the boy. Another boy was also in the room at the time, witnessing the horrifying event. Instead of calling for help, the brothers drove Dakari to Frodtert South Hospital, left him there, and fled. He was pronounced dead at 2:15 p.m. Authorities filed formal charges on June 20th.
We'll call State of Wisconsin versus Jovan M. Cannon. State of Wisconsin versus Jovan D. Cannon.
Jovan was charged with homicide by negligent handling of a firearm and multiple drug-related offenses, while Jovan was charged with leaving a loaded firearm accessible to a child.
When the court read this criminal complaint, I assume that its reading was of heartbreaking stupidity for the two adults who have criminal liability in this case.
During their court appearance, the case was described as horrendous and a preventable tragedy. In court, the defense claimed Jovan tried to stop the boy from handling the weapon and was in shock when it allegedly unaware it was loaded.
He was in absolute shock when he heard the gun went off and he had no idea that the gun was loaded.
It's a preventable tragedy, at least on its surface.
The court commissioner expressed disbelief over their decision to leave the hospital without staying with the injured boy. Cash bonds were set at $10,000 for Javon and a $3,500 signature bond for Jovan, as the case now moves forward through the legal system. In April 2022, 19-year-old Leah Davis was fatally shot at her apartment near 66th and Lisbon in Milwaukee. Her ex-boyfriend, 20-year-old Kashawn Rousey, was accused of the crime. Neighbors reported hearing persistent knocking on Leah's door, followed by firing. Court documents later revealed the two had ended their relationship just 3 weeks prior. A friend of Leah told investigators that Rousey had become increasingly possessive and had previously threatened her life, even telling her he had bought a weapon. Prosecutors allege that on the day of the shooting, Rousey showed up at Leah's door, and when she opened it, he opened fire. Rousey was charged with first-degree intentional homicide and made his first court appearance on April 27th.
And the maximum penalty is life imprisonment plus 5 years. Do you understand the penalty, sir?
Yes, but
During the hearing, it was disclosed that after the shooting, Rousey called one of Leah's friends and confessed, saying he had shot her. He was ordered held on a $250,000 cash bond and is scheduled to return to court for further proceedings.
This is a very hurtful time for us. We will miss her. She will definitely be missed.
Homicides don't just organically happen. Talk to someone, make a phone call our hotline, text, call a friend, and for that friend and family member, be a safe presence.
Leah's family and friends later held a vigil in her memory, and advocates from the Sojourner Family Peace Center reminded the public that leaving an abusive relationship is often the most dangerous time for victims. In June 2023, Matthew and Wheelerot Hernandez took their daughter Emma to the hospital after noticing unusual marks on her body. Medical staff conducted scans and found several small fractures. Concerned, they alerted authorities. As a result, both Emma and her older sister were placed in protective custody, and the couple was soon charged with child cruelty and aggravated battery. The state accused them of harming their daughter, but the family consistently maintained their innocence, explaining they had no idea how the injuries occurred. Over the next 2 years, the Hernandez family fought to clear their names. Their case gained public attention through media coverage, which spotlighted families facing similar accusations. In May 2025, a jury in Forsyth County heard the case and returned a verdict in under 5 hours, finding both Matthew and Wheelerot not guilty on all charges.
The jury is smart, and we win.
They did it.
They did it. I'm not really surprised. I mean, I know the whole time that I'm not guilty, and we are telling myself that I'm not guilty. No matter what happened today, I'm still not guilty. And I know that God on my side.
The emotional outcome not only vindicated the couple, but also led to legislative changes in Georgia, ensuring parents now have the right to seek an independent medical opinion in such cases, helping protect families from potentially wrongful accusations in the future. Just days after graduating from the San Francisco Police Academy, 28-year-old Ryan Kwong was arrested for driving under the influence and causing a serious crash. On the night of May 17, 2025, Kwong was allegedly celebrating when he drove his BMW into the back of a minivan in San Francisco's Sunset District. The collision, captured on surveillance video, left 3 people injured, one of them critically. Sources reported that a family was inside the minivan. Kwong made his first court appearance on May 22nd before Judge Gregory Siren. His attorney entered a not guilty plea to 4 DUI-related charges and reckless driving.
He's incredibly sorry for what happened. His thoughts right now are for the people who are injured and hopes that they have a speedy and full recovery, and he accepts responsibility for what happened.
Kwong's attorney expressed his deep remorse, stating that his thoughts are with the injured victims and that he takes full responsibility. Despite his clean record, the judge imposed conditions for his release. He must wear an ankle monitor, avoid alcohol, and attend counseling. His next hearing is scheduled for June 2025. On March 4, 2025, police in Caledonia, Wisconsin, responded to a tragic scene after receiving a 911 call from Reed Galinsky. Officers found him at the front door, holding a weapon, stating his mother died because of him. Inside the home, they discovered the body of his 47-year-old mother, Suzanne Galinsky, who had suffered fatal wounds. Reed later admitted to the killing, claiming he had taken several of his brother's anxiety pills to feel high and had been inspired by a Netflix documentary on the Menendez brothers. He confessed he had planned to attack both of his parents, but ultimately targeted only his mother after failing to locate a weapon.
Next is State versus Reed Galinsky appearances. Brooke Erickson appears for the state. Members of the victim's family are also present in court in the gallery.
Reed Galinsky appears in person with attorneys Francesca Ballesteri and Alex.
We're here for the preliminary hearing. Attorney's ready.
We're prepared to waive the preliminary hearing this morning. I believe co-counsel filed the waiver form.
I do have it. Okay, Mr. Simpson, did you talk to your lawyers about waiving the preliminary hearing?
Yes, I did.
At a preliminary hearing, the state calls witnesses to testify to prove probable cause that a felony has been committed and that you probably committed it. By waiving the hearing, you're agreeing the state can prove probable cause, and I can order you to stand trial on the charges. Did you understand what the waiver meant?
Yeah, I did.
Did anyone make any threats or promises to force you to waive the hearing?
No, they didn't.
Do you freely, knowingly, and voluntarily waive the hearing?
Yes.
All right, based on the foregoing and the facts in the complaint, I find there is probable cause that this defendant committed the alleged felony in the criminal complaint. I'm going to bind him over to stand trial on the charge. And then with regard to the arraignment, do the parties want to go forward today?
No, Your Honor. We did file a request for a reverse waiver. I believe we already have a date picked out in front of the assigned branch.
Okay, we'll give you a reverse waiver hearing.
Thank you.
Reverse waiver hearing, June 16th at 1:30.
Thank you.
Thank you.
Reed Galinsky was charged as an adult with first-degree intentional homicide. At his court appearance, he was ordered held on a $1 million bond. He showed little emotion as prosecutors outlined his disturbing confession and the calculated nature of the attack. The court has since ordered a mental health evaluation to assess his psychological state and competency. As of the latest update, Galinsky remains in custody, with further court proceedings scheduled to determine whether the case will proceed to trial. In 1989, Oscar Franklin Smith was convicted of killing his estranged wife, Judy Robird Smith, and her two sons, Jason and Chad Burnett, in their Nashville home. The incident, described by authorities as a domestic tragedy, shocked the local community. Smith was arrested and later sentenced to death in 1990. Over the years, his execution faced multiple delays, including a last-minute reprieve in 2022 due to protocol issues. These delays prompted a statewide review and eventual revision of Tennessee's execution procedures. On May 22, 2025, after 35 years on death row, Smith was executed at Riverbend Maximum Security Institution under Tennessee's new one-drug protocol. Before the execution, Smith expressed his belief in his innocence and offered final words criticizing the justice system. For the victims' families, it marked the end of a long and painful chapter, offering a measure of closure. On September 8, 2024, a shooting in Kent County, Michigan, ended the life of 25-year-old Kenivia Howard Broley. Investigators later revealed that Anthony Lamar Buxton shot Kenivia as she was trying to run away from him. Police arrested Buxton soon after the shooting. Prosecutors charged him with second-degree murder and felony firearm possession. From the start, the case centered on whether the shooting was justified or intentional. Buxton's defense tried to suggest Kenivia had come to his home and posed a threat, but evidence and witness testimony contradicted that claim, showing she was fleeing when she was shot. The case went to trial in Kent County Circuit Court in the spring of 2025. Over several days, jurors heard from detectives, forensic experts, and people close to both Buxton and Kenivia. The prosecution argued Buxton knowingly shot her, and the jury agreed. He was found guilty of second-degree murder and using a firearm in the commission of a felony. At sentencing on June 11, 2025, Kenivia's mother, Pecosha Browley, described the impact of losing her daughter, but the focus remained on Buxton's actions.
I wonder if you could identify yourself.
My name is Pecosha Browley. I'm Kenivia's mother.
Fair enough.
Sorry about my voice. I just got over the flu.
Yeah, I get it. Go ahead. You can take your time. There's nothing easy about any of this.
The day my daughter was born will always be a day in my heart. However, Mr. Buxton cast a memory that I'll never forget. On September 8th of last year, I received a call that I would never stop replaying in my head. I was told that my daughter had been fatally shot in the back and that I needed to identify her body. Looking back on that day, everything seems like a big blur, which is why I didn't read a statement. But there's one thing that sticks out to me, and that is the fabricated version I heard when I first got to the hospital, which was that my daughter had went to Mr. Buston's home and tried to assault him. And even though my daughter was dead, I thought to myself, wow, my heart goes out to his mom, because I can only imagine how she felt, because my daughter tried to take her son. And I turned to my best friend who was there with me at the time, and I told her I need to go apologize to her. But I had no idea that that wasn't the truth. He had everybody believing that my daughter played a role in his demise, when it was the exact opposite. He shot her in her back while she was running away. Throughout the trial, I refrained from speaking poorly of him and his family. I never spoke in anger to anyone or even about him, even though he stole my baby's life. Took her away from my grandson, who was 5, who asked about her every day, who woke up that day and went to the grocery store and came back and didn't have a mom. Could you imagine leaving your mother and going to the store and coming back and she's gone? His life has been completely abrupted. He's been taken away from us and everything that he knows and uprooted with his father. And all we did is visitations when we had it to where we could see him whenever we wanted, because he was minutes away from us. However, in return of my daughter being taken away, I received dirty looks. I received things said about my daughter. I received foul whispers, and all of that is very unorthodox, because at the end of the day, I lost a child. We're here today because of his actions. Whatever journey Kenivia had on this earth, it did not define her by what she did. Her job did not define her. Her actions did not define her. She was young. She was 25. I can't think of one person who is not emotional at 25 years old. She was a mother. She was a daughter. She was a sister. She was an aunt. She was a friend. And she was a light to many people. She never met a stranger. Most importantly, best mom to a little boy who wakes up every day and says that he loves Jesus because that's who takes care of her now. She would help anybody willing in need. She was passionate and she loved her family. I had many emotions throughout the trial. From beginning to end, a lot of things stuck out to me. I can remember the second court date we came to where he asked for bail. And he had his lawyer boast about his 15-year marriage. And I thought to myself, wow, 15 years. And that's how you repay your wife. And you use that as leverage to try to get bail. You really think after killing somebody that you deserve to be out in the world with the rest of the people? Not saying that everybody out here is a law-abiding citizen, but you literally shot my daughter in the back and you used your 15-year marriage to ask for bail. And I thought, shame on him. For whatever you were to your stepkids, for whatever you were to your wife, you're a failure. You're a failure to them. You're a failure to anyone who looks up to you because you cheated with my daughter when you didn't have to. You have blamed her through this whole thing when it started with you, because had you never cheated on your wife, we would not be here. Your actions have affected my family as well as yours. She's gone. You're a murderer, and shame on you. You're a sorry excuse for a man. And I hope that you spend every day rotting in prison the same way we have to spend every day without my daughter. My heart goes out to your family. I have nothing against them. I blame you. This was all a result of you. It's men like you that should really be buried because you have no business manipulating girls at that age to make them react the way they do. Because had you been faithful to your wife and had you not even been where you were, none of this would have happened. Your wife wouldn't have had to suffer the unhingement of my daughter. And she wouldn't have to see her be humiliated by your actions, and my family would be suffering for losing her.
She told him she hoped he would spend every day in prison remembering what he did, just as her family has to live every day without Canivia. Anthony Lamar Buxton was sentenced to a minimum of around 19 years and could serve up to 35 years behind bars for taking a young mother's life and leaving a family with an emptiness they will never forget. In August 2016, Shauna Elliott, then a Texas State University student, spent the day floating the San Marcos River with friends near San Marcos, Texas. After hours of drinking, Elliott got behind the wheel to drive home on Highway 21 with a blood alcohol level more than twice the legal limit at 0.199. While driving drunk, she crossed the center line and crashed head-on into a car carrying Fabian Guerrero and his pregnant wife, Christian Guerrero. Fabian died at the scene, and the crash also took the life of Christian's unborn. At the crash site, Elliott tried to hide evidence by tossing a liquor bottle from her car. Later, police searching her apartment found marijuana and heroin.
Were you intoxicated that day?
Yes, I was.
Should you have been driving?
No. We had decided to go float the river, and we weren't thinking ahead. We didn't plan who was going to be driving. It's really blurry. I just remember as soon as the accident happened, I knew that I made the worst decision.
Elliott was arrested and charged with 2 counts of intoxication manslaughter, 1 for Fabian and 1 under Texas law for the along with intoxication assault. During her trial, Elliott took the stand, admitted she had been drunk, and told jurors she accepted responsibility for causing the crash. She spoke openly about her troubled upbringing and mental health struggles, but said they were no excuse for her actions. After hearing all the evidence, a Hays County jury found Elliott guilty on all charges.
I want to say to the victim's family that I'm sorry. From the deepest of my heart, I'm guilty. Whatever's fair for y'all, whatever y'all punishment, I'm accepting of it because I accept responsibility.
Before sentencing, Fabian's widow, Christian Guerrero, faced Elliott in court and told her directly that her reckless decision had destroyed a family and left her with a lifetime of pain that could never be undone.
The past year and 7 months thinking about what I would say to you. Don't cry. Don't cry. Every time it changes. But looking at you today, knowing what I know, I'm not quite sure you're capable of understanding any dialogue that isn't enabling your poor behavior and decision making. This entire time I've struggled with my faith, not to be angry towards you, and forgive your friends and family for enabling you. I almost felt sorry for you that your own friends didn't care whether you lived or died that day. They just let you go. I thought it wasn't your fault that your family didn't care enough to teach you a lesson, but instead threw money to get you out of jail. And in doing so, you became my problem. But you don't deserve my pity. I don't know what's worse. What you said when you were drunk, accusing my husband and I of drinking that day at the river, or when you were completely sober on the phone with your boyfriend just months after you murdered my family, discussing our fictitious involvement in the cartel. You have shown you are incapable of remorse And you don't want to know what it's like to take full responsibility for your actions. Instead, you point the finger. You pointed the finger at your boyfriend for the drugs that you knew about, that you used. Instead of taking responsibility, you're blaming, you're othering. You're a coward. You even tried to point the finger at us for claiming we caused the accident. You were driving You saw us at the river. You saw me taking You're a liar. But I'm not them. I won't take the fall for you. I don't care about your troubled childhood. I had one too. It's no coincidence you haven't seen my mother and my biological father in this courtroom since this trial has started. I grew up messed up too. I didn't have anyone come to my rescue to bail me out of anything. There's no excuse. I had to grow up fast. My husband, his family came over here with nothing. They worked day in and day out for their family. Did you see us out there doing anything illegal? Did you see us out there selling drugs? Did you see us out there people? No. And that's the difference between you and me. At 21, my husband had already provided for our household. He already made his intentions for our future family very clear. At 21, you're out there murdering people. You don't know me. You don't know what my life was like before Fabian. He finally made my world safe, stable. I finally felt safe. And you stole that from me. On August 2nd, you made a decision for my family we had no say in. You made a decision for my son that his parents had no say in. My husband made a vow to me in a room full of all of our loved ones, November 14th, 2015, that his arms would always be my home, and you took that from him. We didn't ask to be on the road with you. We didn't put that bottle that you so swiftly threw under your car before you came to tug on my husband's lifeless body to your mouth. If I was out on bond for drug charges, I'd be mortified. I'd be hiding out at home. But what were you doing on that Tuesday? Out having a good old time. Couldn't even wait for the weekend. Just went on about your life because you never had to deal with any real consequences. While we were out there trying to make a better life for our family, you were out there with no remorse for your previous crimes. You said you prayed for forgiveness? Is that before or after you accused us of drinking at the same place you were? My husband was in the room. You were outside accusing us of being drunk. How do you live with yourself?
Prosecutors recommended she serve 7 years for each count of manslaughter and 10 years of probation for the assault. The judge ordered the 2 prison terms to be served back-to-back, giving Elliot a total of 14 years behind bars. The judge also ruled that once Elliot finishes her prison term, she will spend time in jail each year on the anniversary of the crash, while on probation, a reminder of the lives lost because she chose to drive drunk. In early 2025, a petition for interlocutory appeal was filed in the case of Garner v. Cadence in Kansas in the Utah Court of Appeals. Attorneys Douglas Durbano and Richard Bednar submitted the filing, which included several legal citations meant to support their clients' arguments. Unknown to the court at the time, at least one of those citations, Royer v. Nelson, did not actually exist in any real legal database. The source of the problem came to light soon after. Opposing counsel discovered the citation could only be traced back to ChatGPT, an AI tool that had hallucinated the case. Further review showed that some other cited cases were also misquoted or misapplied. It turned out that an unlicensed law clerk in the firm had used AI to help draft the petition, and Bednar, the supervising attorney, signed it without fully checking the references. When the errors were flagged, the Utah Court of Appeals ordered a special hearing, which took place on April 22, 2025. At the hearing, the attorneys openly admitted the mistake, explaining that there had been no firm policy in place to guide how AI could or could not be used in legal work. Bednar told the judges he had trusted the law clerk's draft and did not verify each citation before signing and filing it under his professional license.
This filing was a serious mistake. My clients apologized to the court, to opposing counsel and their clients, and certainly to their own client. They are embarrassed about this. They are disappointed in themselves and in the failure of their normal process that led to the filing of this petition. I don't know how much you want to hear from me up front, but I'd like to explain what we think happened here and what the firm has done to measures it's taken to make sure it doesn't happen again. And if I may, I'd like to add a little bit of background about Mr. Durbano and Mr. Bednar that leads up to the filing of the petition. Doug Durbano has practiced law in the state of Utah since 1984, and during that entire time has been a member in good standing of the Utah State Bar Association. Mr. Durbano had little, if any, involvement with this petition for interlocutory appeal. He's, of course, been involved in the underlying case. Doug was involved in a car accident on February 12th of this year, and for the next week or so was in the hospital recovering and out of the office, returned to work on February 19th. This petition was filed on February 18th. It bears his name, but it does not bear his signature. Richard Bednar is the attorney responsible for approving, signing, and filing the petition. Richard graduated from BYU Law School in 1989. He then clerked for 2 years in Washington, D.C. at the U.S. Court of Appeals for Veterans Claims, and then remained a staff attorney with that court for about 15 years and ultimately returned to Utah in private practice. Because of his involvement in the court system, he has a deep understanding and commitment to the accuracy of court filings. He has never used AI to generate a brief or to generate case citations, with the exception of the LexisNexis AI tool. But his practice has always been to review and approve cases before they are cited in any filing with the court. That didn't happen here in this instance. What happened here was that Richard asked a law clerk in their office to prepare the initial draft of this petition. Richard then did some work on it, and he and the law clerk exchanged drafts back and forth as those things go. And ultimately it was filed. He did ask that those case citations be checked, and later learned that didn't happen. But Richard did not do that himself. He does not point fingers at others. I'm simply trying to add context. He takes responsibility for this. He is the licensed lawyer who signed the petition, and it was filed with the court.
So do I infer then that it was the law clerk who used ChatGPT to generate some portion of the filing?
Yes, that's correct. That's correct.
Is the law clerk licensed to practice law?
No. No, and that's why I say Richard takes responsibility. He's the one who is licensed. They work together on the document, of course, but ultimately the lawyer who signs and files it is the one responsible. We all know that. And Richard's not trying to hide from that responsibility today. I'm happy to...
Was Mr. Bednar aware that ChatGPT was being used to draft the petition?
No, he was not. And thank you for that question. I began by saying this was a serious mistake, and it was, but it was a mistake. It was not knowing. I don't believe it even satisfies the standard for recklessness. He did not know that AI had been used to generate anything in connection with the brief until after the fact, when they went back to try and reconstruct what had happened here, and then learned that yes, it had been.
And were there any conversations at any point prior to this brief being drafted about the use of AI in their practice and at their firm by this law clerk or any other employees?
To my knowledge, no. I don't think I've asked that specific question. But I've certainly asked that question about, going forward, and that AI was used. We acknowledge that in the generation, but I don't believe that Richard or Doug knew that in the drafting stage before it was filed.
And I'm asking more generally, did the firm have a policy, maybe something less formal than a policy for their employees about using AI or ChatGPT to generate work product?
I don't believe so. And I can stop to ask my clients specifically if you would like, but we've had a number of discussions and they haven't mentioned that to me, so I don't believe that was any kind of a policy. I can tell you there is a policy now.
The court made clear that this wasn't a simple typo. Judges stressed that when lawyers sign a court filing, they are vouching for every word and every citation as real and reliable. The idea that fake cases could appear in legal briefs threatens the entire court system's trust in the legal profession. One judge remarked that the courts can't serve as a backstop for sloppy work. Lawyers must take responsibility to ensure AI-generated content is accurate before it ever reaches a judge's desk.
Undertakes the counsel
to understand it. Some few months ago, judges were all asked to take a poll about AI and their use of AI and so on, and then there was an open-ended question at the end, and I completed that question by saying, as far as I'm concerned, there's so much real intelligence in the judicial branch, we don't need the artificial intelligence.
Yeah. I understand that. I think the last thing I was going to say was just to point to some case law. Rule 3.3 talks about knowing and reckless, and there's some history with that. It didn't always say reckless, but I haven't found any citations to mens rea standards in the context of the rules of professional conduct, so I looked to the broader Utah law for that. This is well defined in many cases. Negligence is a failure to exercise the degree of care which a reasonable person would have exercised under the same circumstances, whether by acting or by failing to act. And I believe if the court is looking for a mens rea standard to latch onto, that's the one that I think fits here. Utah law, interestingly, defines recklessness within the context of gross negligence. That recklessness is subsumed by the court's definition of gross negligence, and that is the failure to observe even slight care. It is carelessness or recklessness to a degree that shows utter indifference to the consequences that may result. I don't believe the facts here can satisfy that standard. That is for the court to determine, of course. But if you ask me, does it satisfy the negligence standard, I would have to say I think it probably does. But
In response, the firm said they had created a formal policy banning the use of generative AI for legal research or drafting without thorough human review. They also offered to pay the opposing side's legal fees for the time spent responding to the bogus petition. In May 2025, the Utah Court of Appeals imposed further sanctions. The attorneys were ordered to pay their opponents' costs, refund fees to their client for the flawed petition, and make a $1,000 donation to a legal aid nonprofit as a reminder that trust and accuracy are non-negotiable in legal work. Gregory Rice's life came to a tragic end in October 2020 in what investigators described as a murder planned by his ex-partner, Megan Jackson, and her lover, Christopher Donnell. Gregory and Megan had a rocky relationship for years. They split for good after years of fighting and mistrust, but Gregory stayed involved with his daughters and son, picking them up almost every weekend. In the months leading up to his disappearance, Megan began an affair with Donnell, a married man who lived nearby. The affair eventually came to light when family members discovered what was happening behind closed doors. On October 2nd, 2020, Gregory was supposed to pick up his daughters and son as usual, but never arrived. The next morning, Megan told police she couldn't find him and claimed she had searched his house and car with no sign of him. Weeks later, in November, fishermen found Gregory's body in the Little PD River. Detectives quickly zeroed in on Megan and Donnell after finding cell phone records and surveillance video linking them to the crime. Footage showed Donnell buying the same supplies used to hide Gregory's body. Location data placed both of them near Gregory's house on the night he vanished. Under mounting evidence, Donnell took a plea deal and testified that he helped Megan carry out the and cover it up, telling jurors she fired the fatal shots. During the trial, Gregory's oldest daughter, Savannah Rice, testified about what she'd seen and heard at home. She told the jury about her parents' constant fighting, her mother's affair with Donnell, and a chilling comment she overheard her mother saying that she hoped Savannah's younger sister would end up like her dad. Savannah said she came forward because she wanted the truth about what happened to her father to be heard.
I met Chris because I, one, knew that he worked with my mom, but two, we moved into his neighborhood and I met his family and we started to hang out with his family and him.
So when you say his family, was he married?
Yes.
Did he have children?
Yes.
How many kids did he have?
He had 2 children.
Do you know about how old they were?
I believe the son was around maybe 1 and the daughter was 6, I believe.
Yeah. And you said that you guys moved into the same neighborhood as the Dontel family?
Yes.
About how far away did you live from them?
It was like 3 minutes right down the road, just down our street and down another street and into a cul-de-sac.
So was it walking distance?
Yes.
Did your family and the Dontels spend a lot of time together?
Yes.
At some point, did you come to know that your mother was having an affair with Christopher Dontel?
Yes, but not at first.
Okay. How did you find out about the affair?
I had some friends over and it was quiet. We went downstairs and we heard them having sex in their bedroom and it just kept getting louder and louder. And the next day I asked her and she said, "I thought you knew."
Do you know about how long that was before your father went missing? And if you don't, it's okay.
I don't remember.
Okay. This will sound like a silly question, but do you remember when your father went missing?
October 2nd.
What do you remember about sort of that time period?
Before or after?
Right after, when you found out that he was missing. So October 2nd was a Friday night, right?
Mm-hmm.
What happened the next morning?
She woke up, we all got up. She got the kids ready to bring them to our dad's, which I already thought was weird because he always came to pick them up and he would come in to see me or I'd go out to see him, which it didn't happen this morning. So she got the kids in the car and...
If you just take some time to breathe, it's okay. Do you need some water?
She brought the kids to his house and she called me and she was really frantic. She said she had searched everywhere. I'm sorry.
It's okay, take your time.
She had said she had searched everywhere. She looked in his car. She couldn't see his keys or his wallet or his phone. She looked in the windows, and then she said she's gonna call the police. And they came back, and that was really just...
When you say they came back, who do you mean?
Madison, Blake, Dakota, my siblings, and my mom.
Okay. So that was the morning of October 3rd. How did your life change after your father went missing?
My mom wasn't home even more often. She wasn't home due to her job most of the time, but it became a lot more when he went missing. Everybody was really emotional. We didn't go out at all. My mom did, but we didn't. We really just stayed in the house.
It's okay, take your time. Do you remember when they found your father's body?
Yes. I do.
What do you remember about that?
I was at my best friend's house, and her mom came in the room. She told me not to go onto any of my electronics, but she didn't know that one of my friends from the neighborhood had already told me. I didn't believe it, but
this is kind of like a big other. Was there anything significant about that day besides the fact that they found your father's body?
That they told us my mom had something to do with it, and that all of my siblings would have to be living somewhere else.
Well, no, I mean, November 7th or 8th. Is there anything about... When's your birthday?
November 7th.
Did your mother ever mention your father during the time between when he first went missing and when they found his body? So you can answer that. Did your mother ever say anything about your father between the time that he went missing and the time that they found his body?
Yes.
Can you just tell us about that? Take a couple deep breaths if you need, but tell us about that.
She had come home drunk one night, and I was in the kitchen, and my sister she wasn't behaving, and I told my mom, and she started screaming. And my sister was upstairs, but then she looked at me, and she said, "I hope what happened to your dad happens to your sister." And I asked her, "What do you mean?" And she just wouldn't say anything.
And that was before they found your father's body?
The jury heard Donald's confession, Savannah's testimony, and saw the digital trail of evidence.
All right, I'll ask the clerk if she would please publish the verdict.
Indictment number 2021 GS 2601191. The State of South Carolina, County of Horry versus Megan Marie Jackson as to the charge of murder. We, the jury, by unanimous consent, find this defendant guilty. Signed by foreperson Jeffrey Roberts, dated June 17, 2025. Ladies and gentlemen of the jury, if this is your verdict, please so signify by raising your right hand. Thank you.
I let the record reflect that all jurors raised their right hand, giving polling of the jury by the defense.
After only a few hours of deliberation, they found Megan Jackson guilty of murder in June 2025. She was sentenced to life in prison without parole. Her conviction ended a story of betrayal and secrecy that cost Gregory Rice his life and left 3 daughters and a son to grow up without their father. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.